This is the video presentation of Hawkins vs Clayton case in year 1988, and the facts of the cases are the defendant's solicitors prepared the retained for safekeeping the executed will of long-standing client, the testatrix, that the will appointed the plaintiff Mr. Hawkins as the sole executor as well as the principal beneficiary of the testatrix estate. The testatrix died on the January 18, 1975, after being informed of her death. The firm authorized the payment of funeral expenses from the funds in the testatrix bank account. No steps were taken to contact the plaintiff to inform him of the testatrix death or that he was the sole executor and the main beneficiary of the estate until March 1981. In November 1982, the plaintiff brought an action against the defendant, soliciting in negligence and contact seeking to recover losses which were suffered as a result of the delay in taking possessions of the estate as executor. The trial court dismisses the action, holding that there was no such contract between the defendant, solicitors, and the plaintiff. The main issues in the case were presented before the court as the plaintiff case was presented in the following manner. Firstly, with respect to the claim in tort that the defendant's solicitors had breached her duty of care owed to the plaintiff personally as well as duty of care owed to the plaintiff in his representative capacity. Secondly, with respect to the claim in contract that the defendant solicitors were in breach of the contract with the plaintiffs as well as breach of their contract with the testatrix. The rules which applies to this case is in the context of ascertaining the duty of care which an architect owes to one who is a stranger to the contract between the architect and the building owner, that the contract is not an relevant circumstance. It determines what was the task upon which the architect entered. The access to the case was the law imposed the duty of the custodian of a deceased testatrix will for the protection of the executor and derivatively for the protection of the beneficiary. It is not a duty owed to the deceased testator. The damage suffered in consequences of the breach of the duty is not a loss of the title to the asset in each estate nor a loss of the executor right to possession of the asset. A breach of the duty does not configure any priority or possessory right vested to the executor by the will. The loss is a loss of the exercise of enjoyment of the rights of ownership by an executor which does not know of his entitlement. As such, loss influenced with the passage of time, the duty disclosed is a duty to disclose promptly. A negligence is not actionable because of the action only occurs when damage is suffered. It is clearly that as early as 1975, the assets of the estate were being wasted, at least in the sense that the real estate was not being used to produce income. The respondent contended that the cause of action then occurred and was thus barred by the Section 14 of the Limitations Act in 1981. On the other hand, the appellant contends that the cause of the action occurred when the damage was discovered or discoverable. All in all, the respondents were not under any duty of care to Mr. Hawkins, either in the capacity of executor of the will, of the testatrix or as a beneficiary. Thank you.